African Americans. Supreme Court Justice Stephen Breyer, at his confirmation hearing, called Brown v. Board of Education the most significant Supreme Court decision in the history of the court. In a unanimous decision written by Chief Justice Earl Warren, the court redefined the meaning of the 14th Amendment. It said that in the field of public education, the doctrine of separate but equal has no place. Segregation is a denial of the equal protection of the laws. It also called upon states to end segregation practices using all deliberate speed. Yet in a survey taken on the 5th anniversary of the Brown decision, many school districts still had not fulfilled the Brown vision. Brown put an end to de jure segregation by law. States and local municipalities have been able to continue the practice through de facto segregation of schools and other public facilities through circumstance with no law supporting it. Housing patterns, schools, and other public facilities have existed where they set up segregation as a basic practice. The Congress and the Supreme Court have attempted to deal with de facto segregation. The landmark Civil Rights Act of 1964 made discrimination in public accommodations such as hotels and restaurants illegal. The law was affirmed by the landmark Heart of Atlanta Motel versus United States in 1964. This case involved an Atlanta hotel on a highway that serviced a majority of travelers. The motel discriminated against African American patrons. It claimed that the Title II provisions of the Civil Rights Act of 1964 was unconstitutional. In a unanimous decision, the court, using the interstate commerce provision of the Constitution, upheld the legality of the law. The 24th Amendment, passed the same year, made any tax related to the voting process illegal. In 1965, the Voting Rights Act was passed. This law protected the right of African Americans to vote and made provisions for federal assistance in the registration process. The Civil Rights Act of 1968, called the Open Housing Act, made illegal the practice of selling real estate based on race, color, religion, national origin, or sex. The issue of busing to solve racial discrimination practices was resolved in the Swan versus Charlotte-Mecklenburg County School case in 1971. The court ruled that busing was a legal means of achieving the all deliberate speed component of the Brown decision. Even though these actions contributed to the civil rights of African Americans, civil disobedience, racial riots, and stonewalling attempts on the part of public officials hampered the progress of the civil rights movement. In a split important decision, the Supreme Court in California Board of Regents versus Bakey in 1978 established two concepts. A majority ruled that Bakey, a white who was denied admission to the medical school, had been the victim of reverse discrimination because the school set up a set of racial quotas that violated Bakey's equal protection. However, in the more important part of the ruling, a 5-4 majority also stated that even though race cannot be used as the sole basis for determining admission, the Constitution and Civil Rights Act of 1964 could be used as a criterion for affirmative action programs. President Johnson, using an executive order, directed all federally supported programs to adopt this criterion. The Bakey case brought the issue of affirmative action into the forefront of civil rights. Both the Supreme Court and Congress have been sensitive to the issue of job discrimination. Legislation and decisions by the court have dealt with the issue and more often than not have accepted affirmative action as a basis of determining whether job discrimination exists. The public has been very critical of affirmative action as a means of achieving civil rights for African Americans and other minority groups. We will deal with it in relation to other groups later in this lesson. Insofar as it has had an impact on African Americans, in 1979 the court again permitted an affirmative action program favoring African Americans in private industry if the program corrected past injustices, the case of Weber versus Kaiser Aluminum. In 1988, Congress passed new civil rights legislation that permitted the federal government to take away federal funds from colleges that discriminate. And in 1991, it passed a Civil Rights Act that placed the burden on the employer to prove that hiring practices are not discriminatory in nature. This 1991 act became a battleground between the Congress and President Bush. Bush initially vetoed the piece of legislation, calling it a quota bill. Congress softened the bill to include the hiring provisions as well as a provision that placed a responsibility on the employer rather than on the worker to determine if any hiring exists were discriminatory. The significance of this act was that Congress, in proposing this legislation, responded to previous Supreme Court decisions that seemed to place the responsibility of initiating anti-discrimination suits on the individual. In addition, it illustrated the heated nature of affirmative action programs. The nature of affirmative action started evolving in a dramatic form during the Clinton presidency. In a major policy speech, President Clinton indicated that he favored a policy of affirmative action that would mend it, not end it. However, individual states moved towards ending it. A Texas federal appeals court ruled that the Bakey decision allowing race to be used as a factor for admission did not apply to Texas state colleges. The California State Board of Regents also invalidated race as a factor in admission in their university system in 1996. California voters also approved in 1996 the California Civil Rights Initiative, also known as Proposition 209. This initiative effectively directed California not to take race or gender into account in government hiring practices. A California appeals court ruled the measure constitutional. The Supreme Court refused to hear the case. Thus, the provisions of the referendum were implemented in California. Because minority enrollment decreased, California instituted a policy that guaranteed admissions to its university system for the top 10% of minority students applying for admission. Even with the significant advances made in the civil rights movement for African Americans, there still is a perception that two societies exist in the United States. The Kerner Commission first established that point after the 1968 rioting and looting in major cities. In a 1988 Newsweek poll, perceptions regarding advances and conditions of African Americans in America showed that whites believed much more than African Americans that African Americans were making gains, being helped by the government, and being treated fairly by the criminal justice system. A 1994 poll in USA Today indicated that there were major differences between white and minority attitudes in key areas of civil rights. Key court cases. Richmond v. Corson, 1989. This case created the impetus for Congress to pass the Civil Rights Act of 1991. It established the following 5 procedures for evaluating the legitimacy of affirmative action programs. 1. A scrutiny test evaluates programs based on racial classification. 2. Congress has more power than the states through the provisions of the 14th Amendment to enforce equal protection provisions. 3. When the state takes action, it must do so on evidence that past discriminatory practice existed. 4. Affirmative action remedies must be specific and apply to past injustices. And 5. States may develop affirmative action programs narrowly tailored necessary to break down patterns of deliberate exclusion.